Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, Fiduciary Duties, the Business Judgment Rule, and Veil Piercing. Let's begin. Directors and officers manage a corporation that is legally separate from its owners, but that separation comes with fiduciary obligations. California essays test whether managers may be held liable for bad decisions, conflicted transactions, corporate opportunities, failures to monitor, or misuse of the entity form. Your organizing move is to separate two questions: internal liability to the corporation for breach of duty and external liability of shareholders or affiliates through piercing the corporate veil. The Business Judgment Rule protects honest, informed, disinterested business decisions. It is not a magic phrase that defeats every claim. It does not protect fraud, illegality, bad faith, abdication, self-dealing, or decisions made without reasonable inquiry. Similarly, limited liability protects shareholders, but it does not protect abuse of the corporation as an alter ego. The best bar answer explains both protections, then explains why the facts do, or do not take the case outside the protection. Duty of care. Directors must act with the care that an ordinarily prudent person in a like position would use under similar circumstances. California directors must perform duties in good faith, in a manner they believe to be in the best interests of the corporation and its shareholders, and with such care, including reasonable inquiry, as an ordinarily prudent person would use. See Cal. Corp Code Section 309. Duty of loyalty. Directors and officers must put the corporation's interests ahead of personal interests. Loyalty issues include interest-to-director transactions, usurpation of corporate opportunities, competition with the corporation, misuse of confidential information, and controlling shareholder self-dealing. Business Judgment Rule. Courts generally will not second-guess a board decision if directors acted in good faith, were reasonably informed, and had no disabling conflict. The rule is a presumption, not an element the plaintiff must disprove in every sentence. Once facts show conflict, bad faith, or grossly uninformed action, the presumption may fall away. Officers. Officers also owe fiduciary duties of care and loyalty. Their conduct may be judged according to their roles and responsibilities. An officer who signs false financial statements, conceals a conflict, or ignores obvious misconduct cannot hide behind the board's general authority. Interest-to-director transactions. A transaction between the corporation and a director, or an entity in which a director has a material financial interest, is not automatically void. It may be upheld if material facts were disclosed and the transaction was approved by disinterested directors or shareholders, or if the transaction was just and reasonable to the corporation. See Cal. Corp Code Section 310. Duty of care analysis. Identify the decision or omission. State the care standard and reasonable inquiry requirement. Ask whether the directors were informed before acting. Apply the Business Judgment Rule if the directors were disinterested and acted in good faith. If the process was reckless or uninformed, explain potential liability and causation. Duty of loyalty analysis. Identify the conflicting interest or personal benefit. Determine whether the fiduciary disclosed material facts. Determine whether disinterested approval occurred. Determine whether the transaction was fair or just and reasonable. Discuss remedies, damages, rescission, disgorgement, constructive trust, or injunction. The Business Judgment Rule is strongest where the board considered information, consulted experts, debated alternatives, and made a risky but rational business choice. Courts do not impose liability merely because the decision turned out badly. A failed product launch, unsuccessful expansion, or over-optimistic investment is not enough if the process was reasonable. The rule is weaker where directors did not read the agreement, ignored red flags, relied blindly on a conflicted officer, failed to meet, or approved a transaction without basic financial information. In California, directors may rely on officers, employees, counsel, accountants, or board committees, but reliance must be in good faith and reasonable. See Cal. Corp Code Section 309. Bad faith is more than negligence. It includes intentional misconduct, knowing violation of law, conscious disregard of duties, or action for an improper purpose. If directors approve a transaction to entrench themselves, retaliate against a shareholder, or benefit a controller, discuss loyalty and good faith rather than only care. Note: do not say the business judgment rule protects officers and directors from all negligence. State the presumption, then identify whether the facts support or rebut it. Rule: shareholders are generally not personally liable for corporate obligations. A court may pierce the corporate veil under the alter ego doctrine when there is such unity of interest and ownership that the separate personalities of the corporation and the shareholder no longer exist, and treating acts as those of the corporation alone would sanction fraud or promote injustice. Unity factors. California courts consider many facts, with no single factor controlling. Common factors include commingling funds, undercapitalization, failure to observe corporate formalities, identical ownership and management, use of corporate assets as personal assets, disregard of separate records, diversion of assets, holding out that the individual is personally liable, and use of the corporation as a mere shell. Inequitable result. It is not enough that the corporation cannot pay a debt. The plaintiff must show some unfairness beyond ordinary limited liability, such as using the entity to mislead creditors, siphoning assets, avoiding known obligations, or perpetrating fraud. Bad decision versus bad process. A losing decision is protected if the process was informed and disinterested. A profitable decision can still breach loyalty if it secretly benefits a fiduciary. Care versus loyalty. Care focuses on attentiveness, investigation, and decision process. Loyalty focuses on conflict, self-interest, and fairness. If facts show self-dealing, lead with loyalty. Director conflict versus shareholder conflict. Directors owe fiduciary duties because of office. Controlling shareholders may owe duties when they use control to benefit themselves at the expense of minority shareholders or the corporation. Veil piercing versus fiduciary liability. Piercing makes shareholders liable for corporate obligations. Fiduciary breach makes directors, officers, or controlling shareholders liable for misconduct. They are different theories and can appear in the same essay. Starting with damages before identifying the duty. State care, loyalty, or alter ego first. Applying the business judgment rule to a conflicted transaction without discussing disclosure, disinterested approval, or fairness. Saying an interested transaction is automatically void. California law permits validation if statutory protections or fairness are shown. Piercing merely because the corporation is insolvent. Insolvency is not enough. Forgetting officers. The chief financial officer, president, or general counsel may be a fiduciary even if not on the board. Suppose the board approves buying land from a company owned by Director Dana. Dana says nothing about ownership. The board reviews no appraisal, and the price is above market. Analyze loyalty first. Dana had a material financial interest, failed to disclose it, and the transaction appears unfair. Disinterested approval is unavailable without disclosure. Remedies may include rescission, damages, or disgorgement. Also analyze care for the other directors because they approved a major purchase without reasonable inquiry. The business judgment rule likely does not protect an uninformed approval based on concealed conflict. Now suppose Dana is the sole shareholder of Landco, which never kept records, paid Dana's personal mortgage from corporate funds, was undercapitalized when it signed environmental cleanup contracts, and transferred assets to Dana after breach. A creditor seeks Dana's personal liability. Apply alter ego. Unity of interest is shown by commingling, diversion, lack of records, and shell use. Inequitable result is shown by siphoning assets to avoid known obligations. Piercing is likely. A top answer is disciplined. For each defendant, identify capacity, director, officer, shareholder, or controller. For each claim, identify doctrine, care, loyalty, corporate opportunity, business judgment rule, or alter ego. Then apply facts to protection and exception. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.